Hi, I'm Dominic Chalfie. I'm with Aegis Professional Services, and I'm going to be your guide through the first 100 days of your startup. Today we're going to be talking about company formation. So we're going to be talking about your company in its infancy. Things like your choice of entity, where jurisdiction are you going to form your entity, and the operating agreement. So in order to illustrate, I've come up with my own hypothetical startup business, Hypochondriac. Hypochondriac is a mobile medical diagnosis application. So what you're going to do is say you have some type of ailment. You simply open up Hypochondriac, answer a series of yes or no questions, and eventually it will lead you to a diagnosis and then suggest a list of medical providers for you to go to. Hypochondriac has 3 founders. They're all in their late 20s, Albert, Bob, and Charlie. They're headquartered in St. Louis, and they'd like to stay here. The goal for them is to have a larger company eventually purchase their technology. Now, why do I talk about their goals? Well, the goal is important in relation to their exit strategy. Now, that might seem like a contradiction. Why are we talking about an exit strategy before you've even started their business? Well, it's important. For one thing, founders have a tendency to be very good about starting their businesses without necessarily thinking about how they're going to get their money out of businesses. So I'm going to go over 4 general exits for startups for you. The first one of those is the lifestyle business. The lifestyle business is actually more of a non-exit strategy in that, let's say Albert, Bob, and Charlie, they think they want to retain control of the business. They're going to manage it for the foreseeable future. They're going to use the profits from the company to pay their own salaries, and they get to choose basically whatever salary they want to in the lifestyle business because they have control. Well, the problem with the lifestyle business, not only is it very difficult to do to sustain that on your own, but it also limits your growth potential. For one thing, every dollar that you pay yourself in salary is not a dollar that's going to be reinvested into the business. Second of all, if an investor knows that you're going to keep this as a lifestyle business, and it's going to scare away investors because an investor is looking at an investor has their own exit strategy that they're looking at. An investor is looking to get their money out in 3 to 5 years. So they don't have time for somebody who wants to stay in a business for 10, 15 years or more than that. The next exit is a liquidation. The great thing, a liquidation happens when you sell all the assets of your business for cash and ride off into the sunset. Hopefully wealthy, but probably not. Of course, you don't have to worry about negotiating any acquisition. You don't have to worry about controlling the company for an unforeseeable amount of years. But what is the bad thing about it is that your assets obviously are going to be less liquid than cash. Therefore, you're going to not be able to recover the full value of your assets that you have in your business. Another thing is that liquidations usually occur involuntarily. It's when your business is not being very successful, and you're forced to liquidate. On the other hand, it's not necessarily good if you have a successful business and you decide to liquidate. As you would imagine, the investors could be very frustrated about that situation. Next, we have the acquisition, and I would say most of our clients that come into Aegis Professional Services and most of the St. Louis ventures that I've encountered are looking for some type of an acquisition. An acquisition occurs when a larger business comes in and purchases a smaller business, most likely for some type of piece of intellectual property or goodwill. And in these cases, these are very attractive to investors because the perceived value, say the larger business is looking at this as a strategic acquisition, the perceived value of the larger corporation or business probably is going to exceed the actual value of the startup business that's being acquired. So obviously that leads to a great potential of return on investment for investors, and obviously very attractive to the founders of the business as well because they may get that 3 to 5 year exit that they're looking for and be freed up to start new ventures if they have other ideas. If Albert, Bob, and Charlie aren't necessarily married to Hypochondriac. One thing that's actually happening more often is a thing called acqui-hires. So this is a situation where we have a hybrid between an acquisition and the hiring of the founders of the company, essentially assimilating the founder, maybe one or more, as employees of the larger firm. This can be difficult for founders. It sounds very nice because they still get to have a piece of be a part of their startup, but it can be hard for a founder because once they had all managerial control and control the destination, it can be difficult to lose that once they're hired on as an employee. Albeit they may be a very important cog in the machine, yet still just a cog in the machine. One important thing to note about acquisitions is if you come up with if this is your strategy from the get-go, one thing you can do is have a target for what type of company or maybe a particular company that you would wish that would acquire you. I'm not saying to pigeonhole yourself, but you do want to ensure a good fit between yourself as the startup and the acquiring company, so it doesn't quite blow up in your face if an acquisition happens and it doesn't turn out to be a good fit. One example of that might be Time Warner and AOL. Just think of a more prominent example. Next, of course, last but not least, we have the IPO, the initial public offering. We all think about Mark Zuckerberg. Obviously, he's a very prominent figure with Facebook, his initial public offering and all the problems that happened there too as well. But the great things about an initial public offering, it's the holy grail, right, of exits. You're rich, you're famous, blowing hookers all night long. That's always good. But the cons, obviously, okay, these are very rare. Like I said, it's the holy grail. For 99% of businesses, this is going to be unattainable, initial public offering. That's not a bad thing. It takes millions of dollars in legal fees, which I would love, but I don't want to do that to people. As an attorney, I can't. Millions in legal fees sounds great, but transaction costs. This is just something that's not sustainable for most startup businesses, even as they become more and more successful. It's just very expensive. Okay. So, hypochondriac, going with my initial thought that most St. Louis ventures are looking for an acquisition strategy, I said hypochondriac, Albert, Bob, and Charlie, their exit strategy is going to be acquisition because they feel like they have an exciting new technology. They need to attract investors, and that's the 3 to 5 year window that investors are looking for. That's going to get the investors the return on the investment that they want. They're not necessarily interested in managing this company forever because they have multiple venture ideas. So the acquisition sounds good to them. So what now? They have to form their company. And what company do we form? So as hypochondriac is now, currently, it is a non-statutory entity. There's a couple of different non-statutory entities, the first being the sole proprietorship and the second being the partnership. The only difference is the number of owners in each one. A sole proprietorship, by definition, will have one owner. Then there will be no legal distinction between the owner and the business. So therefore, the owner is going to be personally liable for all debts of the business. So for instance, hypochondriac gets into a contract with a contractor. Hypochondriac is allegedly breached the contract, and contractor wants to sue hypochondriac. Well, say that they are successful, not only can the contractor obtain the assets of hypochondriac, they can also obtain the personal assets of Albert, Bob, and Charlie. Their house, their cars, anything that's not protected. So the partnership, very similar to the sole proprietorship, but there's a multitude of partners. So there's multiple owners. And in the default position in a partnership, all partners are going to be treated equal. If there's 2 partners, each partner is going to get 50% of the voting rights and 50% of the distribution of losses, of profits and losses in that company. If there's 3, it's each going to get a third of the voting rights and a third of the distribution of profits and losses. Now that can all be changed, and it usually is, with a partnership agreement. We'll talk a little bit about that later. It's very similar to an operating agreement. We're going to talk about that. Much like the sole proprietorship, the partnership gets the pass-through taxation, and we have personal liability as well. Corporations, finally we get to a statutory entity, the first one being the corporation. The corporation gets limited liability, which means if we have the same instance where we have a contractor that is suing Hypochondriac, the contractor can win the assets of Hypochondriac, but they are not eligible to go after the assets of Albert, Bob, and Charlie. A corporation is owned by its shareholders. The shareholders then elect a board of directors that manages the strategy and overall direction of the company. And then the board of directors appoints officers, which then control the day-to-day operations. The birth of the corporation comes at the filing of an articles of incorporation with the Secretary of State in whatever state that you choose your jurisdiction. And some investors are more comfortable with the corporation because there's been so much case law and there's more protections for shareholders and the corporation itself from maybe the malfeasance of its managers that might occur. One decision you get to make with a corporation is how is it taxed, and the default position would be a C corp. A C corp is doubly taxed. It's taxed on the income from the corporation at the corporate level. And then when it's distributed to shareholders, it's taxed as well at that level. One thing you can do to alleviate that problem is elect to become an S corporation. An S corporation has the same type of pass-through taxation, and it's only taxed once as a partnership. But there's a caveat to that. Only certain companies can be eligible for S corporation election. What they have to do is an S corp can only have one class of investors. They can have not more than 100 shareholders, and their shareholders must be natural persons, which means there's no institutional investment, and they must be U.S. citizens as well. Finally, we get to the limited liability company. This is a relatively new type of entity. And it's very popular because it's very flexible what you can do with a limited liability company. Once again, we have no personal liability, so they're not going to be able to go after your cars and houses. And we get a choice of the tax regime in this situation as well. We can either be taxed like a partnership with the pass-through taxation, or we can be taxed as a corporation as well. You get the choice. We can also be managed by our members, or we can be managed by a manager. Member-managed limited liability company, say we have Albert, Bob, and Charlie, and they are the members of the LLC, and they're going to manage the day-to-day operations together. In a manager-managed corporation, Albert, Bob, and Charlie, they may decide to appoint a manager while they take on a more passive role, and that manager, they might pay the manager to take on the day-to-day operations of the LLC. The great thing about the LLC is there's less formal organizational structure and record-keeping requirements in the corporation. Like I said, it's more flexible. You can decide, with a corporation, you have to have meetings of the shareholders at certain intervals, but not in a limited liability corporation. You have more flexibility when you want to meet. You don't necessarily need to have resolutions for every single type of decision making that you need to go on in a corporation. So you can be LLC can be more agile, I guess, in a way, than a corporation would be able to be. Okay. One problem that deters people from the limited liability company is, like I said, since it's a new type of entity, there's not as much case law about it. So some investors can be more comfortable with the protections and provisions in statutory law and in common law, being case law, that are provided for the corporation.